Don't waste time. Put your baby to breast within the first 1 hour of delivery to give that first yellowish milk colostrum. Colostrum has all the important nutrients your baby needs to start a healthy life. Colostrum also helps to protect your baby against diseases. Remember, put your baby to breast within the first 1 hour of delivery. This message is from the ANRIN Project or your State Ministry of Health.
Hey baby, before I forget, I'll be traveling on the 25th of this month. I have an emergency conference. Please help me arrange.
Come in.
Daddy, Mommy, as the firstborn of this family, I would like to call a quick meeting.
We are all ears, my baby girl. What do you want?
Children's Day is approaching.
Yes.
And you know that every year we attend 32 FM, Smart Kids, and Parents Hangout at Park Mall, Ibadan. This year, this event will be even more interesting because I get to showcase my musical talent to the world.
Tommy, so where are you going with all this?
I overheard that saying he was traveling on the 25th of May.
My sweet baby, I wouldn't want to miss hanging out with you and your brother and mommy for anything in the world. We shall all be there.
Oh, I love you both.
Smart kids, smart mommies and daddies. Saturday the 25th of May will be a day to remember as the Smart Kids and Parents Hangout will be happening live at Palms Mall, Ring Road, Ibadan. Get ready for a really amazing time, and this year is filled with games, goodies, and lots of fun. We shall also be spotlighting our super talented kids. If you can sing, dance, paint, or draw, contact Auntie Sumbo on 0704-017491 for more details. For tickets, sponsorship, and inquiries, contact Auntie Sumbo on 0704-0174981 or OE on 0813-125-1915. You can also visit 32FM at the 4th floor, Cocoa House, Dubai, Ibadan. Ticket is 3,000 naira only. The Smart Kids and Parents Hangout 6.0 promises to be fun. See you there.
Ẹ̀yin fans mi. It's okay. Ẹ lọ sórí gbogbo ìkànnì ìbánidọ́rẹ̀ẹ́ ní 32FM 949 fẹ̀yìn àsápù. It's okay.
Wá mọ bó ṣe lọ.
Lágbèrè ìdárayá nílẹ̀ yìí àti nílẹ̀ òkèèrè.
Ẹ máa gbọ́ Sporting Crystal àtàwọn olùkú rẹ̀.
Láago 5 sí 6 àrọ̀lẹ́ lójoojúmọ́.
Àtàgò 1 sí 3 ọ̀sán lọ́jọ́ àbámẹ́ta. Ẹ gbọ́dọ̀ míì sí ẹ̀.
Ege!
Àbẹ́ ò rí nǹkan. Ẹ̀bùn pàtàkì látọ̀dọ̀ Ọlọ́run lọmọ jẹ́ fáwọn òbí. Tómi ọyàn sì jẹ́ ẹ̀bùn Ọlọ́run fáwọn ọmọ. Ó ní gbogbo èròjà aṣaralóore pẹ̀lú omi tọ́mọ rẹ nílò. Fún oṣù 6 àkọ́kọ́, máa fọ́mọ rẹ ní ọyàn nìkan. Rántí o, omi ọyàn nìkan fún oṣù 6 àkọ́kọ́. Ìkéde yìí wá láti àkọ́ṣeṣẹ́ INT'L, iléeṣẹ́ tó ń mójútó ètò ìlera ìpínlẹ̀ Ọ̀yọ́.
You're listening to 32 FM 94.9.
Welcome back, the Podium on 32 FM 94.9. Remember, we're live on Facebook, 32 FM 949 Fenye. We're also live on YouTube as well on the same handle. Before we went on that break, we were discussing the challenges and the possible impact the student loan might have on the education system, because the portal, according to Mr. 𝐂𝐑 goes live in about 6 days. Barrister, you were making a point before that break.
Yes, I said in a country where a portable can be arrested for a purely civil matter, as far as I am concerned, and the law too, it is not a country I think anyone will want to hold out his head in fulfillment of some of the recommendations, some of the requirements for accessing the said loan. That's one. Secondly, you see, I don't know exactly what the government is up to, because as far as I am concerned, it appears it is the same lackadaisical attitude, that has always been with the educational sector that is still manifesting itself. How much loan can a student access when, for instance, Prof would buttress this, the notice that came out a short while ago from the premier university, the minimum an incoming student will pay is 350,000 naira. It is as high as 450,000 naira per session. In a country where, let us clap for federal government, that it has increased minimum wage from 30,000 naira to 48,000 naira. When I did the analysis here yesterday, that 48,000 naira would only pay for the transport fare of the father and 2 children who go to school every day, 5 days a week, 3 months in a term, and for 3 terms in a year. So the money will not even be enough. If he gives his 2 children 200 naira for transportation every day, they will not eat. They must not eat. And the wife must be a log of wood. She must not have life, and there's so many other things. And they will be completely shut out from supply of electricity because many of those who are on minimum wage, I don't know if they have a band for them, but whatever band they are in, that was not, addressed in the so-called new minimum wage. Their rent, accommodation, and all that. I don't know if that. So, all of these together, and a university is going to be charging 450,000 naira. What then is this loan going to achieve when the children cannot even go to the school?
This loan is going to help them go to the school. That's the essence.
How is it going to help them go to the school?
By providing funds for them.
What fund is it going to provide? How much fund is it going to provide? Is it going to give them 450,000 naira to pay for their tuition? That's the point. Because what it would do is just to assist those who are in school. What you want to do? There's nothing there that says they should be paying their school fees and stuffs, But the question is, can the student access 450,000 naira to meet the requirement of the universities of their choice? So, because this is very, very fundamental, you need to be in the school to access the loan. You can 1 minute.
Yes.
There was something that caught my attention yesterday from one of the forums, WhatsApp forums I belong to. He loves to be addressed simply as Kochi, and he asked, students should take loans for education, but federal government can conveniently subsidize religious tourism. Who did we offend? That's the catchy poser yesterday on the forum, and that's the question we're asking. How sincere is the government with this education wahala?
Okay, let me just read some sections of that act to address some of the issues that Prof raised earlier. The act stipulates that the process and structure through which NEL fund will be funded. According to the act, the student loan program will be financed by allocating 1% of all taxes, levies and duties that the Federal Inland Revenue Service collects, and the ones that go to the federal government, directing these funds to a generated reserve fund. Now, the applicant's family income that was under the initial law must not exceed 500,000 naira per annum, but it was revised. The requirement has been removed, and family income will no longer be a prerequisite for the eligibility of the student. It also stipulates that an applicant must provide a minimum of 2 guarantors. The guarantors must fall into the following categories: civil servants and lawyers, as I mentioned earlier. The application is not restricted to tertiary institutions alone, but also those seeking skill development program. It is inclusive to those who want to learn vocational or technical skills in a government-owned institution but do not have the resources to do so. It also stipulates that recovery process from beneficiaries would commence 2 years after the National Youth Service Corps NYSC scheme. It stipulates punishment for those who provide false statements to the fund. Such person is guilty of a felony and is liable to imprisonment for 3 years. There's also a debt forgiveness clause. It offers a debt forgiveness clause in the event of a death or acts of God causing inability to repay. They said that the updated act addressed hindrances in the initial version that will address all of these challenges. Let me go to Prof now. I mean, Prof, some of these sections I read out, I hope it has answered some issues you raised earlier. And also, I'd like to get your take, because I've seen the take of the National Association of Nigerian Students, who have thrown their support behind this, and ASU has vehemently opposed this policy. Students are saying, why is ASU opposed to this? If you're actually looking for the welfare or looking out for the welfare of students in your advocacy, in your series of strike action, if you're looking for a better university system, why are you opposed to this?
Yeah, because they know very clearly that the idea is a ruse. I mean, you read the provisions of the Act. What exactly in that provisions can you say are specific? The NEL fund is still going to provide guidelines and is going to we have to define some of these parameters. You say institutional fees. What are institutional fees? You understand?
Yeah.
If you say you're going to pay sustenance, to what level? These are things that have not been defined. So that's why, the law, I'm not saying that the law is not adequate. I'm saying there's still a lot of information or decision making that still needs to be done by NEL Fund in order to operationalize those provisions of the law. So they have not done all of those things. They've not, what level of awareness in terms of procedures and requirements have they put out there? You are not going to allow make students to depend on the broad provisions of law in order to know exactly what their entitlements are. I also mentioned that when you say institutional fees, are fees consistent across universities or institutions? What exactly is it concerning cost of living, for instance, that you want to fund? Are you going to divide the country into different economic zones so that those who live, who are from the southwest, for instance, or even from Oyo State, you will not expect them to have the same subsistence with somebody, for instance, in Unilag, where cost of living is a little bit higher. So there are so many parameters, so many issues that needed to be clarified that have not done. Okay. That's why I'm saying that. Is it until when students get there? Then let's go back to the position of ASU.
Yes.
ASU has always maintained, and if you go to the chapter 2 of the Nigerian Constitution, the directive principle of state policy, education is one of the major goals of the Nigerian government. And we do not believe that today the federal government cannot fund public education. And they have also demonstrated that funding is not their problem because they keep creating new institutions, which means they have more than sufficient funds to run current ones, and they are in fact going on to provide. So
you think funding is not the problem, Prof? For what is on ground right now, funding is not the problem?
Yeah. No, and if you read from the behavior of the government, funding is not the problem. For instance, you give 90 billion to subsidize Hajj. You understand? Now you look at some of these banks.
Prof, looking at the let me come in there. Sorry, looking at the challenges that the University of Ibadan has, for instance, the infrastructure, the hostels, and everything. Can 90 billion, fully renovate that university, for instance? So how many universities can it renovate in Nigeria? That 90 billion in terms of funding and infrastructure challenges. What can it do?
You first of all ask, what can 90 billion do in terms of infrastructure? Because it's the same government that has put that kind of 90 billion. Why don't it establish in phases, allocate that kind of money to intervene in the infrastructure or even the facilities of universities annually, and say, okay, in the first 3 years or this year, this is the number of universities that we're going to give money out of the 90 billion, and the following year you do the same thing. In no time, in 10 years, you cover all
Prof, how much was ASU asking for? How much was ASU asking for infrastructure development in the universities in the first place?
ASU was asking for about 600 billion at that point.
Oh.
Intervention. was never paid. In fact, they were supposed to be paying about 300 billion every year for a specific period of time. Not a single, and government will tell you that they don't have the resources at all. Now, when we are talking about these universities, remember you are intervening through student loan. So, what are you concerned about the students? What do you really want to meet? Is it that to keep them in school? Now, what that loan is it for them to pay tuition fees? Because even now you've already put a cap on the universities and say they can't charge fees. So what are those? What are you actually really paying for? Is it the service fees that we are talking about? So I think if the government wants to intervene, it should intervene decisively rather than paying lip service to it. Now you are going to see the bottlenecks that are going to be on the way of the student because there are so many things that are unclarified.
So you should intervene through ASU. You should intervene through ASU, not the student.
Why should he intervene through ASU? Well, even the requirement of ASU is not true. It's not through ASU. It's direct to the university authorities, and that's why sometimes we quarrel with ASU and say, "Look, it is the committee of vice chancellors that will be fighting for all these things you are fighting for. Fight for our remuneration only." But these ASU people think that they should be patriotic. They should fight for the good of society rather than for their individual members. There's a great tension within ASU itself over this matter. So all those things that ASU is clamoring for, it's not for us, it's not for members. And we keep telling them, look, focus on our own bread and butter issues. If the government decides it wants to bring infrastructure on, but ASU insists that no, it will be irresponsible of them to just focus on bread and butter issues. And there are tensions. And so it's not that the ASU is saying, pay this thing through ASU. No.
Okay.
ASU is not responsible for
infrastructure. Barrister, before we welcome our guests for the day, let's wrap this up.
Thank you very much. I think Prof has said so much. One point he made now, I'm not sure, I've not read the details of that government says they cannot charge fees. If that is the position, then that will be most welcome, if the universities are not charging fees. Because I read, that the fees in UI would rise to about 450.
That's if the federal government stops subsidizing the tuition.
Yes, it will. But
the tuition.
No. Those fees are not tuition fees. They are services from the university. For instance, in terms of electricity, how much electricity costs?
So exactly where I'm going, Prof. My position is this: is the federal government not taking away with the left hand what it is giving with the right? Because for a student to be able to access that loan, he must be one that has been so admitted as a student. Now, how many of the parents? Federal universities are about the cheapest.
Yes, they are.
So you can imagine what will be coming from the state universities. Don't even let us go to private universities. So are we not going to shut out a great number of our children who will not be able to access, education with all of these high fees? Then secondly, has the government also taken cognizance of this fact that the unemployment market continues to swell every day? So when they talked about the act of God, they have not, like Prof said, have they really defined it?
And there's a grace period, 2 years after NYSC.
Yes.
2 years.
So if we have people who have masters who have been out there for the past 5 years, would it be regarded as an act of God if upon graduation and service, a student is unemployed for 2 years? Shouldn't that also be a part of what is defined as an act of God? Before they bring their koboko as
well, very interesting conversation. Let's hope that it does kick off on the 24th of May and all these challenges are addressed. Our guest is already with us now. It's Barrister Olaleko Joe, SC, and is a senior advocate of Nigeria. Thank you so much for joining us on the podium today. Great to have you, sir.
Thank you. Good morning, and I thank you for having me on this program.
Yes. I think I was telling Prof last week that we had two professors on the show. So now we have two learned people on the show as well. Barrister Emil Gorola is one of our panelists on the podium. Barrister, please welcome our guest.
When Bolabo was telling me about 𝐿𝐿 yesterday, I was like, maybe there was so much in my head. I said, 𝐿𝐿𝐿. It was when I was out driving, I was like, but now my very, very big senior is now is Silk.
Yes.
𝐿𝐿, it's so wonderful to have you with us.
Thank you very much.
Yeah.
Once again, I thank you for having
Yeah, is it Learned Silk that they call it? Learned Silk.
Oh, yes.
Yes, Learned Silk. All right. Professor Remi Ayede is also here with us, our panelist. Prof, please welcome the Learned Silk.
Yeah, welcome, senior advocate. It's a pleasure to have you on the podium.
Thank you, my dear professor.
Yes. Sorry, let's begin, sir, with the drama, never-ending story in Rivers State. That's like the hottest state in the country right now. It looks like there are different issues that come out of there on a daily basis. Let's begin with the defection of the 27 lawmakers from the PDP to the APC. That has elicited different reactions. The governor, I think some weeks ago, said that the assembly members do not exist, that he's only allowing them because he wants peace to reign by virtue of signing that peace accord. There are those who are saying that going by precedent set by different courts in the country, the lawmakers should have forfeited their seat, hence they're no longer valid members of the State House of Assembly. What's your legal perspective on this, first of all? Because some say this is where the crisis got complicated from the defection, and the presidential peace pact has said that the assembly members should be reinstated. Are they still valid members from your legal perspective?
Well, thank you very much. The question of defection has been well settled in a plethora of decided cases. The law is today tried that unless there is a division in a political party, unless there is a division within the context of the law, not just imagined or conjoined division. Any legislator that defects where there is no such division in his party automatically loses that seat. In other words, it ceases to be. I do not think there is any debate this.
So
the only issue that can be passed, depending on which side of the divide you belong to, is whether or not there is a division in that party, PDP, in Rivers State.
Oh, okay, so would you say that the governor then should have stood his ground before signing that peace pact? Because if, from what you're saying, from the past court judgment, the precedence has been set, except there is a division and the party is polarized, you have no grounds for defection. If you do so, you will forfeit your seat. So the governor, would you say, made this whole thing complicated by putting pen to paper and appending his signature to that presidential peace pact?
Well, on a more serious note, the governor saw the whole scenario as being politically motivated. He saw it as a political problem, and it was convinced that a political solution was what was required. So to that extent, he didn't make any mistake in signing that presidential peace pact. However, the fact remains that even his signing it does not necessarily change the position of the law. It's like a court that does not have jurisdiction. Parties cannot, by consent or acquiescence, confer jurisdiction on a court that does not have jurisdiction. Similarly here, the governor even lacks the power, with all respect to His Excellency, the governor lacks the power to confer or to confer legality, constitutionality on something that is not. So in my view, it is irrelevant that is signed up. Right. He can still insist that in law, these legislators, assembly members have ceased to be He cannot waive it.
Right.
He cannot waive it.
Before I go to our panelists, very quick one. There are those who have explained that that peace plan can be seen in the context of an out-of-court settlement, because there is an advocacy for alternative dispute resolution now, that you can settle out of court instead of overburdening the courts with all of these long cases. That if you can, sign and resolve your matter, it could be seen like that. Can it be seen in that context, like an alternative dispute resolution mechanism, which can also be valid in the eye of the court?
Well, with the greatest respect, when you have, there are two categories of out-of-court settlement. There is one that parties may agree to and outside the court, and it ends there. There is another one that is also filed in court, and the court will enter what is known as consent judgment on the basis of the terms. To the best of my knowledge, the Peace Pact was never filed in any court. The Peace Pact was never filed in any court. So it is, at best, it does not have the status of a consent judgment. However, it has the status of a contract, of a binding contract, an agreement now, entered into by the parties. To that extent, it is not a useless agreement.
Right. Let me go to our panelists now. Let me start with Barrister Ogunola. Barrister, you have the floor.
Yes, I would have loved to ask a question on what you have just, what the learned silk just submitted on, and that is with respect to the parties to that agreement, whether they possess the requisite standing, in a federal arrangement. But let me leave that. Maybe
we'll go back to that later.
Yes, before we go, the learned silk may address those issues. Let me go to the real problematic areas of the judiciary. Quite a number of people are questioning the efficacy of the judiciary, particularly to international businesses and its reliability to its citizens. As a matter of fact, depending on the divide to which you belong, many consider the judiciary now as being infamous, arising from delays, limited access, high costs, getting justice, archaic procedures and principles, weak administrative capacity, and of course, we also have corruption. My question, learned silk, is with respect to judicial independence, the ability of courts and judges to perform their duties free of influence or control by other actors, whether governmental or private. How do you assess the judiciary today in Nigeria?
Thank you very much. This is a very, very important question. As far as I am concerned, the Nigerian judiciary as at today is sufficiently independent. And the Nigerian judiciary as at today is sufficiently independent. What are the parameters to assess judicial independence? Security of tenure, financial autonomy, to some extent, welfare. The legal framework in Nigeria today has enabled our judiciary to be independent. What you have today, sir, with all due respect, and it's very unfortunate, but you see, there is one thing for you to be independent.
Learned Silk, sir, please hold that thought. We need to quickly take this commercial break. Please hold that thought, sir. When we get back, I'd like you to finish your line of thought. We'll be back in a moment. Please stay on the line.
Okay.
Feel better about your life.
32 FM 94.9, the antidote to depression.
Àbẹ́ orí nǹkan ẹ̀bùn pàtàkì látọ̀dọ̀ Ọlọ́run lọ́mọ jẹ́ fáwọn òbí tómi ọyàn sì jẹ́ ẹ̀bùn Ọlọ́run fáwọn ọmọ. Ó ní gbogbo èròjà aṣaralóore pẹ̀lú omi tọ́mọ rẹ nílò. Fún oṣù 6 àkọ́kọ́ máa fọ́mọ rẹ ní ọyàn nìkan. Rántí o, omi ọyàn nìkan fún oṣù 6 àkọ́kọ́. Ìkéde yìí wá láti àkọ́ṣeṣẹ́ INT'L, iléeṣẹ́ tó ń mójútó ètò ìlera ìpínlẹ̀ Ọ̀yọ́.
Èrò máa wá o, ẹ̀dá gírí máa bọ̀ o. Tiléeṣẹ́ mi wá ń tó kalẹ̀ sójele. Kónílé ó gbọ́ o, kálejò gbọ́. Ẹ sọ fàdán kóró fún bẹ̀. Iléeṣẹ́ mi wá Naturalist Care Limited ti kalẹ̀ kà sóje. Ọlọ́run ló kúkú dirí ẹwà fákùkọ tiwa. Gbogbo oògùn tó ń jáde níléeṣẹ́ mi wá ń pátá ló wà níbẹ̀. Lówó tí ò ga jara lọ. Pẹ̀lú irinṣẹ́ ìgbàlóde lóníranran. Àwọn akọ́ṣẹ́mọṣẹ́ ń bẹ níkàlẹ̀ fáyẹ̀wò ara. Àwọn fi tó wa létí wípé àǹfààní ń bẹ fún gbogbo àádọ́ta ènìyàn kọ́kọ́ 50 tí wọ́n bá kọ́kọ́ ń dé lójúmọ́. Ẹ máa gba káàdì ọ̀fẹ́, àyẹ̀wò ọ̀fẹ́. Ẹ tún máa fi ẹgbẹ̀rún 3 náírà 3000 péré gba ògùn lọ́dọ̀ wa. Ẹ tara ṣàṣà máa bọ̀ ní Àjọkẹ́ Plaza ní dojúkọ Swift Oil tó wà ní Tèmídìrí Òjé Ìbàdàn. Ẹ̀lọ́ wa ní 08034405133. Ẹ̀mí one ló sọ wípé ànífà ìsọsọdún o.
Bá jẹ́ 24, 29 tàbí 32 ṣáà ti fẹ̀yìn ẹ̀ pẹ̀lú wa lórí gbogbo ìkànnì ìbánidọ́rẹ̀ẹ́ kàn tẹ 32 FM 949 fẹ̀yìn ẹ̀.
Gàrí olóyè ó ti ládùn tẹ́lẹ̀ àgbèrè ní ṣúgà ń gbé tẹ́lẹ̀tẹ́lẹ̀ o.
Gàrí ọ̀kan pàtàkì nínú oúnjẹ tó ń léwájú nílẹ̀ Áfíríkà tó ti wá di ìtẹ́wọ́gbà káàkiri àgbáyé báyìí. Ó ń fúnni lókun ó sì tún ń fini lọ́kàn balẹ̀ ṣe déédéé ara ẹni láti wá gbádùn gàrí yìí bẹ́ẹ̀ ṣe ń fẹ́. Ìjẹ̀bú gàrí ní kẹ́ ẹ dìbò fún tá a gbé jáde pẹ̀lú ẹ̀gẹ́ tá a ti ró lágbára níléeṣẹ́ Oyigis Farm Foods. Ìjẹ̀bú gàrí mọ́núnú kò dọ̀tí kò pàkúta bẹ́ẹ̀ ló dùn tó ń lọ lọ́fun tìrín. Wọ́n ti pákéjì Ìjẹ̀bú gàrí lẹ́jẹ̀wọ́n lọ́nà tó fanimọ́ra bíi 500 grams 1 kg 2 kg 5 kg 10 kg tó fi dórí 50 kg níléeṣẹ́ Oyigis Farm Foods. Gbogbo ayé ló ń dúrà ní wìtìwìtì bí wọ́n ṣe ń ṣe gàrí jáde lẹ́tún lè rí ọ̀pọ̀lọpọ̀ oúnjẹ eré oko rà bíi bell peppers cabbage lettuce carrots tó fi mọ́ ẹ̀gẹ́ tẹ́ fẹ́ dára tó wù yín àtẹ̀fọ́ pẹ̀lú tomato àti bẹ́ẹ̀ bẹ́ẹ̀ lọ. ẹ kàn sí Oyigis Farm Foods lónìí ní shop 2D4 GSM International Market Ẹlẹ́yẹlé Ìbàdàn telephone 0706 423 7147 pẹ̀lú Ìjẹ̀bú gàrí ẹ jẹ́ fọkànbalẹ̀.
ọmọ mi ti pọ̀ṣù 6 ẹ bá mi dúpẹ́ oṣù 6 ẹ bá mi dúpẹ́.
Ó ti yẹ pọ̀ṣù 6 nìyẹn. Ọmọ ò máa ń pẹ́ dàgbà o. Báyìí o ọmọ rẹ ti wá nílò ju omi ọyàn nìkan lọ o. Àkókò ti tó láti máa fún un ní oúnjẹ fífọ́ ní àfikún sí ọyàn. Rí i dájú pé àwọn oúnjẹ ọmọ rẹ ní ó kéré tán ọ̀kan lára àwọn oúnjẹ àfọ́pọ̀ 5 wọ̀nyí: ẹyin, ẹja tàbí ẹran, èso àti ewébẹ̀, epo tàbí òróró, ẹ̀wà, ẹ̀pà tàbí sóyà, ìrẹsì, ọ̀dùnkún, àgbàdo tàbí iṣu. Ọmọ rẹ bẹ̀rẹ̀ láti oṣù 6 nílò omi ọyàn àtàwọn oúnjẹ wọ̀nyí fún ìdàgbàsókè àti ìlera. Máa fún wọn lọ́yàn títí yóò fi pé ọmọ ọdún 2 àti jù bẹ́ẹ̀ lọ. Ìkéde yìí wá láti àkọ́ṣeṣẹ́ INT'L, iléeṣẹ́ tó ń mójútó ètò ìlera ìpínlẹ̀ Ọ̀yọ́.
You're listening to 32 FM 94.9. When the people became silent,
The government became oppressive. It's time to lend your voice to politics.
On 32 FM 94.9.
All right, welcome back. 32 FM 94.9, your laughter station. The program is The Podium. We're live on Facebook, 32 FM 949 Fenye. We still have 𝐂𝐿𝐒𝐿𝐒 SCN with us this morning. So welcome back, sir, from that break. Please finish your line of thought. Can you hear me, sir?
Thank you.
Yes, sir. Okay.
Yeah. Well, I'm saying that the constitutional framework in Nigeria today has made the Nigerian judiciary to be sufficiently independent. There is this very popular quotation in those days in Julius Caesar. Said, men sometimes are masters of their fate. The fault, dear Brutus, is not in our stars, but in us that are underlings. It is what the cases you have today are cases of some members, some judicial officers deliberately surrendering their independence to external influences. They have the right, they have the capacity to say, no, do not, they can even threaten to get any such person arrested. And if such a thing should come from the executive, they have the right to say, please do not interfere. Just like the case of the Yoruba, it is a cockerel that let the fox to know that what is on its head is not fire. What am I saying? We have a case of some judges consciously surrendering their independence to either the executive or other external persons trying to influence them. It is of their own making. The fault is not in the law. For example, look at what happened in Osun State recently with regard to the moves to either suspend or
remove the CJ.
It became so clear that the governor, even the House of Assembly, cannot remove a CJ. And they can also not remove a judge of that state. Because removing either the CJ or any judge must involve the participation of the NJC.
Yes.
So how can you not say that they don't have the independence? But some of them choose to surrender their independence for whatever means.
But Leonard Silk, the issue of financial autonomy remains controversial. I don't think, have we been able to resolve that? Because that could also be a big hindrance, to their independence.
Yes, I know to some extent that the issue of financial autonomy has not been fully achieved. Nevertheless, you may know their basic salaries are paid by the NJC. It is their allowances, like furniture and the rest housing, that are still being to a large extent handled by the state, and that is the last phase. But even there is now is the statutory and statutory legal frame to ensure that they have 100% autonomy. The CJs of the states. That is blueprint. But I do not think that is enough for any judicial officer to do what he is not supposed to do. No judicial should just obey whatever dictates that is inconsistent with the impartial discharge of his duties as a judicial officer.
Right.
That is an excuse.
Right. Let me go to Professor Ayede now. Professor Ayede, Department of Political Science, University of Ibadan. Prof, you have the floor.
Yeah, thank you very much. I think I agree with the learners here concerning the position on the independence of the judiciary. I think he has made it very clear that we must distinguish between the rules of the game and the behavior of the players. Thank you very much. Now,
very apt, Prof. Very apt. Very apt. Yes.
I'm going back to Rivers State. There's this argument that even though those 27 members of the House of Assembly have defected to another political party, there is the argument that it is not the responsibility of the governor to begin to treat them as if they are no longer members of the House of Assembly until a court so declares. And people think that to that extent, the governor is acting illegally. What's your opinion on that?
Oh, do we still have the Leonard Silk?
Hello?
Okay.
Yes, okay, yes.
Is that question?
Yes, that question is for you, sir. Yes, sir. It's for you.
Okay. Thank you very much. Thank you very much. Well, I agree totally that notwithstanding the well-settled position of the law, there is still the need for a declaration from the court that they have lost their seats by virtue of their defection. Because no governor can constitute himself into a court of law. The governor ought to have instructed his attorney general or any other person in that office to approach the court for a declaratory or relief to that effect. And he can even say, pending the time that such a declaration will be made or will not be made by the court, they should be restrained from exercising their functions or duties as members of the Rivers State House of Assembly. This is necessary in order to avoid or prevent this kind of argument. So I agree to that. It should have gone further. Yes, no matter how well settled the position of the law is, to make it applicable to a particular situation, you must do the proper thing. And what is the proper thing? Get a court order declaring that position as applicable to these 27 lawmakers. If I were to advise him, that is what I would have told him.
Okay.
I see now why he had to replace his attorney general.
Okay. Sorry, sir. I want to also quickly, as we wrap up the Rivers conversation, or maybe I don't know if Barrister has more questions on Rivers, but I just want to ask you where you think that, how you think that this can be resolved. We've seen the first intervention by the president; it has failed, obviously. What would you think? What would you suggest to be the way forward out of all of this? Another intervention, perhaps, by the president. That's one. Number two is to go back to a judiciary that Barrister Ogunlola mentioned earlier. From what I've observed, it looks like there is this trust deficit. People believe that judiciary is no longer the last hope of the common man. Well, some, depending on the side of the divide you belong to anyway, there are those who say this is the true nature of the judiciary, that people have lost faith in it. There are those who say, look, this is not the true nature. Those who are making people believe that the judiciary cannot be trusted are those who feel disgruntled, perhaps, by how, court judgments have not gone in their favor, especially given how the Election Petition Tribunal played out in the last election and the court judgment that followed as well. Which one is it for you? The trust deficit, does it really reflect the true nature of the judiciary, or just those who feel disgruntled that are fanning the embers of that trust deficit? So those two questions, Rivers and this deficit. Yes, the question is for you, sir.
Okay, for me, sir.
Yes, it is. It is for you. You are a guest. So,
Leonard,
yes,
you are the one on the hot seat.
Yeah, you are a guest. So the questions are for you.
Deficit.
Yes.
That argument is being championed by those who are disgruntled, by those who are not satisfied with the judgments and rulings from the courts or election petition tribunals. Those who won, they will never say there is anything like trust deficit. Nevertheless, I am not saying, and I will never say, that the judiciary is perfect. No institution can be perfect. But the mere fact that you have lost in an encounter does not warrant you vilifying that sacred institution because the rulings or judgments did not favor you. There is this thing we should know. It was an American jurist that said so. Even talking about the Supreme Court in the US, he said, we are not infallible. In other words, judges and justices are human. They are not infallible. But if if that judgment is from the Supreme Court, they said that we are infallible because we are final. So the finality makes them to be infallible. But nevertheless, they have never claimed to be perfect. That is why in some cases, even the Supreme Court has had occasion to review their previous judgments and depart from them. So we must not, my take, sir, the judiciary remains the only hope. Honestly, there is no other. The alternative is a invitation to anarchy, to chaos. I know the distinguished members of the judiciary, the judicial officers, will continue to work towards retaining the confidence, justifying the confidence reposed in them. They have been urged, and they know this, to consciously work towards justifying the confidence reposed in them. But let me make this point. Judgments of courts are reached based on facts and law. The mere fact that a judgment of court does not meet the expectations of certain sectors of the public does not mean that judgment is not good. Judges are not to discharge their duties in a way to pander to public opinion. No, it is not public opinion that determines the outcome of any legal dispute in a court of law. It is not public opinion. It is high time we stop this. That because some vocal members of the public are thinking along a particular way. Therefore, that is what the judgment of a court of law should reflect. That has never been the position.
Right.
Just last one. Look at the presidential election petition. You will remember, sir, it was a highly respected senior advocate of Nigeria that started this issue of Abuja, FCT, ought to be a state. Not only that it must be a state, that a president must also win in FCT. You know, that argument was brought by many lawyers and even non-lawyers. But at the end of the day, what did the Supreme Court say? They say, that cannot be. That is not the intent of the law. So will anybody say just because that decision on the status of FCT did not meet with the expectations of some people, therefore that decision is wrong? No. And permit me to make this point.
Yes, sir.
Matter how knowledgeable, matter how eminent, how knowledgeable anybody can be, in matters of law, as Oliver Wendell Holmes said, he said it is what the courts decide. That is the law. Nigerians must learn to accept decisions particularly decisions of the highest court of the land.
But then what is the role? Leonard Silk, yes, I agree with you. But what about the role the law ascribes to the reasonable man on the street, on his assessment of the judgments of the court?
Thank you very much. You see, reasonable man on the street. The reasonable man on the street is not a judge. The reasonable man on the street is just like 𝐿 just said, of blessed memory. The reasonable man on the street is the reasonable Nigeria at Sangros Market in Lagos. How do you expect such a reasonable man to now critically and correctly assess the correctness or otherwise of the judgment of the Supreme Court?
But it says a good judgment is such that when the reasonable man goes home happy that justice has been served. That's
respect,
you know.
May I come in, sir?
Yes, you can.
That has to do with the issue of fair hearing. How do you determine fair hearing? The fair hearing in a case is determined by the impression of a reasonable man. I agree. And can he go home to say to himself that justice has been done? I agree. But when it comes to assessing the correctness or otherwise, fair hearing means you give both parties or all the parties to the suit the opportunity to ventilate their grievances.
Okay,
let's
leave that there. I have two questions, really, that I also want you to touch before we round up this session, and that is on number one, conflicting judgments. Conflicting judgments have brought the judiciary to near ridicule. I want to ask, why is there, or why have we not been able to improve our reporting technology for judges in real time so that we can resolve this problem of conflicting judgments? And the second question has to do with the very brilliant submission that you made, and also my knowledgeable professor. That is the gap between the vision underlying the principles guiding the legal profession as a whole and the actual situation. Because you said, and I quite agree with you, that there is independence. It is our players that are not taking advantage of what the law has provided. So the second question has to do with the process of selection and the process of training of judicial officers. Could it be that a flaw in those processes are responsible or could be responsible for what we are saying, in terms of the conduct of our judicial officers to take what rightly belongs to them? Do you think there is a nexus between those two?
Thank you very much. Let me start with the issue of conflicting judgments. I agree totally that conflicting judgments have brought the judiciary to public ridicule. And some reasonable members of the society are asking questions. Is it that these judges or these justices are unaware of those previous pronouncements of the law on certain issues? There are two possibilities. The defects in our law reporting systems. But even before these judgments or rulings get reported, can't we have a situation where just judgments and rulings of the Court of Appeal, for example, are circulated immediately they are delivered? Let them, even we don't wait for this for the judgments to be reported in either law pavilion or Nigerian Criminal Report. Let there be a standing directive, a standing practice that at the moment judgments are read, within 48 hours, this is an IT age, circulate all those judgments to all the divisions of the Court of Appeal and instruct their respective presiding justices to circulate or give directives for the circulation of those judgments to each justice of the Court of Appeal. So where such is done, and the panel of the Court of Appeal still goes and deliver a conflicting judgment, such a panel cannot therefore claim to be ignorant of the previous judgment or decision of another panel of the Court of Appeal. For now, they can say, oh, they were not aware of it. Indeed, no, if a legal practitioner, and by necessary extension, a justice of the Court of Appeal, indeed a judge of the High Court, has no right to say he is not aware of a previous judgment that is relevant to the case he is handling. It is not possible. With all due respect, the best lawyer, and I want to believe that our justices are the best available. The best justices deemed to be conversant with the current position of the law. The issue of conflicting judgments is unpardonably bad. And where such happens, with all due respect, there must be, the NJC must have the mechanism of querying such justices or judges. And where a case is made out that it is a case of deliberate failure to follow a previous judgment, then there may be a need to sanction such.
Right. No, right. There is a second question. Yes, I was just I was telling Toba that there is a second arm of the second question, that you have not yet responded to, and that's about the selection, yes, and training of judicial officers.
I agree. That's another very sensitive issue. We are all ad idem that the selection process should be thorough, tough, and bring about the best. However, I am not saying, and I will never say, that the present selection process is perfect. We would continue to improve on it. We will continue. I'm sure the NJC and other stakeholders are interested. They should allow or continue to allow the NBA to also have input, not just comments. No, whatever they say about any prospective judge should not be just swept under the carpet. However, I will not say that because a prospective judge is the son of the CJN or the son of the president or the son of the president of the Court of Appeal, that alone should make him unappointable. I do not think so. We have had children of professors becoming professors. Nobody has said why. The only grounds can only be if that son or daughter-in-law is not qualified.
What about undue influence on the appointing authority? Isn't that also possible?
Why they are? You see, when you have vacancies, say 10 vacancies this year, say for judges of the Federal High Court.
Yes.
And you have 300 candidates. 300 candidates jostling for 10 vacancies. It becomes problematic.
Right. Okay. Leonard Silk, let's move away from that now and look at the issue of corruption, which is, a very major one in Nigeria. It's been there for many years. And the agency, always in the eye of the storm, is the Economic and Financial Crimes Commission, the EFCC. We've seen them with the new EFCC boss emerging now. Some would say they have like this sort of renewed vigor going after ex-public office holders, ex-governors, ministers, senators, even the former CBN governor, Godwin Emefiele as well. I'd like us to start with the operational procedure of the EFCC, which came to the front burner again with the way and manner that the case of Yahya Bello was handled, the way they moved to his residence, the intervention of Usman Ododo, the current governor of Kogi State as well. So I'd like you to speak to the operational procedure of the EFCC, which some say need to be reviewed because they have this Hollywood-like way of operation wherein they call the media attention and everything, go to the residence of an ex-governor trying to whisk him away and everything. Let's speak to that. And also, what do you make of the current EFCC, the drive that the chairman seemed to be displaying? Does it indicate any level of seriousness in the attempt to tackle corruption in this country?
The last question, please.
It's in two parts. The first one is the operational procedure. The second one is all of the cases that we've seen come to light in recent time, the ex-ministers, ex-governors and whatever. Does this show any level of seriousness on the part of the government? Because some would say that this is just what happens. It looks like a cosmetic approach. They make headlines with one big name for the first 4 years and 8 years, and then it goes away. The case goes on for like 10 years and nothing comes out of it eventually. So do you see like a level of seriousness better than what we've seen in the past couple of years in this new FCC boss?
Thank you very much. Let me start with the operational procedures. The EFCC is a creation of statute. The statute has conferred enormous powers of arrest, such powers that the Nigeria police have or possess. These powers are also available to the EFCC. And to that extent, they can go to the house of any suspect and get him arrested. But there must be, these things must be done in a civilized manner. There are other law enforcement agencies outside Nigeria. They don't behave like that. They don't behave like in a Gestapo manner. If you want somebody arrested, invite him formally, not by telephone. Invite him formally. If he does not honor that invitation, it's at that stage that you can now say you want to go there. And in the case of the former governor of Kogi State, the EFCC knew very well. The EFCC knew very well that rightly or wrongly, I repeat, rightly or wrongly, that former governor had secured an order of the High Court of Kogi State restraining his arrest. I'm not saying that I have no power, no competence to say that order was either properly made or improperly made. It is the Court of Appeal that can do that. With that, the back of the mind of EFCC chairman, he should have resorted to the court. He should have followed the due process of law. With that order being in existence, with all due respect, his men had no right to still want to forcibly arrest that. So, what am I saying? The operational procedures must be in line with the rule of law. If there is an order of court, even if you think that order was wrongly made, if you think that order is not worth the paper on which it is written, still approach the court to have that order set aside. After all, why the hurry? If you have cases of ex-governors with you, they have been with you for 4 years, you are not in a hurry. So why must you be in a hurry to get
okay, let's see. Please hold our thoughts, sir. Hold our thoughts, sir. When we came back from this break, you answered the second leg of the question, which has to do with the current FCC, the way they're going after ex-public office holders, whether or not it shows level of seriousness in fighting corruption. That will be after this break. Please stay with us. We'll be back in a moment.
You're listening to 32 FM 94.9.
Baby,
Babies are God's gifts to parents, and breast milk is God's gift to babies. It contains all the important nutrients and minerals your baby needs, including water, for the first 6 months. Give your baby breast milk only. Remember, breast milk only for the first 6 months. This message is from the Anrin Project or your State Ministry of Health.
Ìmọ̀lẹ̀ ní òkùnkùn parada ojúlọ́bàrà Aba capsule ojú ni ìmọ̀lẹ̀ ara Èdùmàrè má gbòde ọ̀sán lọ́wọ́ wa àkànṣe gbòógì tá a fi mọ̀ ìjìnlẹ̀ ṣe fún ìtọ́jú ìmọ̀lẹ̀ tí ìmọ̀lẹ̀ kedere tàbí tó mú báyìí ojúlọ́bàrà Aba capsule egbògi oníkóró ni NAFDAC ló ń tẹ̀ gbà authentic clear vision ló ṣe é wà ní chemist àti pharmacy stores lágbègbè rẹ ẹ tún lè ríra lọ́fíìsì authentic clear vision tó wà business complex lẹ́gbẹ̀ẹ́ Amidu Ajibade shopping complex gate Ìbàdàn àǹfààní ńlá wà fún alágbàtà tó ń kó ní pálípálí.
081-4254-3127 081-4254-3127.
ojúlọ́bàrà Aba capsule tí o bá sí àyípadà bó o ṣe fẹ́ tètè lọ rí dókítà rẹ o.
ojúlọ́bàrà Aba capsule ilé iṣẹ́ authentic clear vision ló gbé jáde.
Báàjẹ́ 24, 29 tàbí 32 ṣáà ti fẹ̀yìn ẹ̀ pẹ̀lú wa lórí gbogbo ìkànnì ìbánidọ́rẹ̀ẹ́ kàn tẹ 32FM949 fẹ̀yìn ẹ̀.
I am pregnant. It is important for me to take care of myself and stay healthy.
To be strong and have a healthy pregnancy, take iron and folic acid tablets every day when you're pregnant. This prevents anemia and helps maintain a healthy pregnancy. Visit your healthcare provider for regular antenatal care. This message is from the Anrin Project or your State Ministry of Health.
Ṣẹ̀mí bí olóògùn ọ̀rẹ́.
Ìjà òdọ́là lètò tó yanjú àwọ̀.
Láàrin mùtúmùwà.
Tóbi lọ́ba Ògúnṣínà wọ̀kìlúmọ̀ látọ́kùn ètò.
Láago 11 àárọ̀ lọ́jọ́ Ẹtì àti Àbámẹ́ta.
Feel better about your life.
32 FM 94.9, the antidote to depression.
When the people became silent,
the government became oppressive. It's time to lend your voice to politics.
On 32 FM 94.9.
Safa sapeli sizo simnyama Iwasafa Isizo saba Yamula mo Alijani mko Kalize Wenhaye wemodo Safa sapeli sizo simnyama.
Welcome back. The Podium on 32 FM 94.9. We still have 𝐂𝐿𝐒𝐿𝐒 𝐂𝐿𝐒, Senior Advocate of Nigeria, joining us this morning on the Podium. In case you're wondering who 𝐂𝐿𝐒𝐿𝐒 is, in case you're just joining us, actually, he's successfully represented a broad range of clients in both criminal and civil matters in Nigeria with some of the issues he's highlighted as well. He's also an active member of the Nigerian Bar Association and the International Bar Association as well. He's been discussing issues relating to the judiciary, the fight against corruption, and the state of the polity as well. Thank you for joining us once again. I'd like you to finish your line of thought, sir, about the EFCC's current operation. Is this just part of the usual razzmatazz that we often see with the new administration? The last administration, they started with the whole Dasuki Gate situation before they moved on to other things. Now this one's starting with the Mefele. There's Yaya Bello here and there as well. Does it show any level of seriousness, or is it just like a continuation of what we've seen in the past?
Thank you very much. I commend the current chairman of the EFCC for what he has started. He has started well. He has started well with the investigation. First, he has assured Nigerians that pending investigations will be concluded. He has also caused criminal charges to be preferred against some of these public office holders. However, I pray and I hope that he will see it through. We pray and hope that there will be nothing like selective prosecution, because previous chairmen of the EFCC have been accused of embarking on what they call selective prosecution. No, there should be no preference to prosecute certain former governors while you close your eyes to other governors or public office holders whose cases are being investigated by the EFCC. For example, the mere fact that somebody is a minister, it's not a minister does not enjoy immunity. A minister does not enjoy immunity from prosecution. So why is it difficult? Recently, I read about some youths protesting about the failure of the EFCC not to conclude the investigation into cases of corruption against some governors, some of whom are in this present government. That is not a good thing. The EFCC must not only be seen, it must be manifestly seen to be pursuing its anti-corruption agenda with decisiveness. Nobody should be spared. The fight must be total. I wish him the best, and I hope that as a lawyer of many years, is over 2 decades, he has promised us that he wants to leave an enduring legacy behind.
Right.
And one way of doing this is to pursue this anti-corruption.
Let me go to Prof now. Prof?
Total commitment. Once a say as not shielding anybody from corruption, as not doing a selective prosecution and investigation, we will all rise up and clap for him.
Right. Let me go to Prof.
And
Prof.
Nigeria will not give him. I mean, we never forget him.
Yes. Prof, are you with us?
Yeah.
Okay.
Yes, I'm here. I'm following.
Right.
In a few, in fact, that's about a week, this government will be.
Oh, okay. It looks like we've lost connection with Prof now. Let's see if we're able to reconnect with Prof and our guests for the day, 𝐂𝐿𝐒𝐿, Senior Advocate of Nigeria. Remember, the podium is live on Facebook, 32FM 949 Fenye. Drop your comments there. We're also live on YouTube as well via the same handle. Let's see if we can reconnect with them. Pending the time, let's see if we can take some comments. I think we have some comments on Facebook already while we re-establish connection with our guests and our panelists on the show. Let's go to Facebook now and take some comment. Okay, Dr. Babatunde says, whatever EFCC is doing must be in accordance with the law setting up the commission. Whenever they see anything wrong with the mode of operation, they should approach the National Assembly to seek moderation or alteration. It is just unfortunate that some people in the country see themselves as above the law. Okay, this one says, those students that were excluded from accessing the loan. Okay, this is about the student loan issue that we discussed earlier on the show. What is the plan in place by the government for those categories of students? What about Nigerians studying abroad? Do they have access to the loan? I guess these are some of the issues that the organization in charge would have to answer. It says the loan is there for students to access. The process would be on soon. I wish students let them access the portal and do the needful. The loan is not for everybody. Some set of people were already excluded. I hope the conditions attached to the loan scheme will be met by the student. Prof and Barris in the studio are ready to serve as guarantors. Okay, let's see if we have barrister. I said if I was still in school, I would approach you to be a guarantor. Okay, we're still trying to establish connection with them. Barrister, let's just talk on a few things that our learned silk. Let me copy you now. Your learned colleague talked about so far.
My learned senior colleague.
Yes.
He's a senior advocate.
He is actually. He is. Especially considering what he said about the operational issues in the EFCC. He says the EFCC has a mandate, to arrest, just like the Nigeria Police Force, but they must review how they go about it. It says the Gestapo-like way of going to arrest suspect should be reviewed by the Commission. What do you make of that?
I think the learned silk aptly captured, what we find unacceptable in the operations of the EFCC. With due respect, you see, law is not about the substantive matters it deals with. It is not just about the substance of law. It is also about procedure. And where you fail to apply yourself to the prescribed mode of exercising an official function, of course the judiciary is there to knock it off. So I think it is very good advice, for those who are occupying official positions to ensure that they comply with the procedures laid down by law for exercising the powers that the law has bestowed on them. And secondly, I was also very, very happy when the learned silk mentioned.
Okay, I think we have him back now.
Okay,
I think we have him back.
Let me conclude.
Okay, yes.
When the learned silk mentioned the issue of what did you call it? Selective
fight against corruption.
Fight against corruption. I think he very, very aptly addressed those two issues. Although I still have a question for him before he goes.
I think Prof was trying to ask him a question before we lost that connection. So, Prof, welcome back. Please go ahead with your question. Prof, can you hear us? Yes, please go ahead with your question for our guest. Yes.
Yeah, that it's in a few days. In fact, the government will be 1 year in office. We've talked about judiciary at length. One other arm of government that the president has been relating with is the National Assembly. And there's this perspective that the National Assembly does not appear to be living up to its bidding. It has more or less become a rubber stamp, given a number of issues that have happened in terms of president taking decisions before seeking the consent of the National Assembly. They also talked about the current president of Senate wearing the logo of the president to the red chamber, and then of course singing the president political song in one of the occasions when he went to make a budget presentation. People thought that the National Assembly could do better than what it is now, that it's no more than a rubber stamp. What's your opinion?
Senior Advocate, are you with us, sir? Please unmute your device, sir.
Leonard Silk, please unmute your device. The question is for you.
Okay. Is it back?
Okay.
Yes, it's back now. Yes.
All right.
Good to have you back, sir. So did you get Prof's question, sir?
Yes.
Okay.
I got the question.
Go ahead, sir.
It is difficult to disagree with the Prof, distinguished Prof, that is situation of things in Nigeria, particularly between the National Assembly and the executive. I'm sorry, permit me to use this pidgin English. Is more of a paddy arrangement. And it is unfortunate. That is a stark truth. It's more of a paddy arrangement. And that is why some people have correctly accused the National Assembly of being a mere rubber stamp. This is not supposed to be. Most of us who are in either late 50s or early 60s, we were very much alive during the Second Republic. The National Assembly you had then was not a rubber stamp. It was a National Assembly that was always ready to call the president to order, to challenge the president. For example, for the past 8 years, how many times have the National Assembly taken the president to court for any alleged unconstitutional conduct? They don't do it. Wait. I'm not saying we need a National Assembly that is confrontational. No. But we need a National Assembly that will be alive to its duties, to the exercise of its oversight duties, to oversight the exercise of the executive powers of the president. This is not the National Assembly we have today. And we are using this opportunity to call on the leadership of the National Assembly to be alive to its duties. The Nigerian electorate voted them. They were not voted to protect the interest of the president. They were not voted to be a rubber stamp. They must engage the presidency, the executive arm of government, whenever it is necessary.
Let me go to Barrister now. Barrister?
Yes. Lion Silk, let me ask you this. Will it be the last for this session? Because I know
we still have about a few minutes to go.
Okay, almost out of time. Lion Silk, I am looking at the fast disposal of cases. I know that has been a very, very problematic issue in the judiciary too, and very many times it has been about manpower and also the rules of court. The new rules of court that most courts appear to have adopted, it looks for the expeditious disposition of cases. But then the issue of manpower came up. But today, thankfully, we have the allowable maximum of justices of the Supreme Court. Just a couple of days ago, there were new appointments of justices of the Court of Appeal. Lagos State was also seen to have its bench swelled up by members. We don't know who we have offended in Oyo State. Our judges, we know. So my question is, with this improvement in manpower, should we look forward to a faster disposal of cases, a more efficient judiciary? Lion Silk?
Hello?
Yes, are you with us? Did you get a question, sir?
I got the question.
Okay, sir, go ahead.
I think I can say, as of today, gone are the days, and the days will be gone forever, where there will be any justifiable reason for the slow pace of justice dispensation. In terms of manpower, we are in order. In terms of, finance to some extent, we are in order. So I look forward to a more expeditious justice dispensation system in Nigeria. However, there is a caveat. If even if the justices or judges are prepared to work, I'm appealing to my colleagues, the lawyers. The lawyers they constitute a veritable stakeholder. We are ministers in the temple of justice. We must be prepared to assist the judiciary in the discharge of their duties. Lawyers should do their own part diligently and within the time. At times this delay are due to the fault of lawyers.
Frivolous adjournments.
I'm to say this. Lawyers, indeed, there are some clients who will brief their lawyers. They know they have no either good defense or whatever. They will say, "Counsel, I just want you to delay this case for me for 2 years." And the system of the lawyer accepted to do that.
It sounds like barrister can relate. It sounds like he can relate to it.
But no, let us see. Yes. Before you go, I know because I still have to report back to the bar.
Yes.
We need judges in Oyo State. What is responsible for our own not coming out now? We need more judges. Our judges are being overloaded, overburdened. On a daily basis, you can have a judge having about 48 cases on the cause list.
Do you know, sir, that in Lagos, we have judges having 60 cases in a day? So, talking about what you have said, I think the bar should engage the executive governor of the state, His Excellency.
Okay.
Engineer Seyi Makinde.
Right. Senior advocate, time is running out. I just want you to speak to these two issues. The first one is regarding the issue of true federalism and devolution of powers that a lot of people have advocated for in the country. The Minister of Solid Minerals, 𝐷𝐷𝐿, has said that state governors should establish mining companies and apply for licenses, that the reforms we made in the ministry now so allow states also have a say in the mining sector. That's one. This is coming after the Electricity Act, which empowers states to generate power, was also signed into law. So with this development, are we gradually heading towards that true federalism in such a way that states will have more powers over critical sectors like electricity? In fact, there's another one about rail transportation as well at the state level. So is this a kind of true federalism that some people are advocating for, empowering the states more to have more powers to administer critical sectors in their domain?
I agree that it's a very good development. It is one thing that should be pursued to its logical conclusion. Look at electricity, rail transportation. In Lagos now, they have the blue rail system.
Yes.
And the red.
That has the red and the red. So that has eased transportation in Lagos. That has also provided employment for many people in Lagos. So let the state be allowed to play in the mining sector, in the mineral sector too. The Honorable Minister has assured us that state governments will be granted necessary licenses to participate, to play, to be an active player in the mining sector in Nigeria. To me, that's a very heavy development, and it will effectuate the realization of true federalism in Nigeria. We need more and more of state government participation in the critical sectors of the economy.
Okay, let me go to Prof now. Yes.
Particularly those areas of the economy that are on the exclusive legislative list, like mines and minerals.
Okay, Prof.
So it is
Yes. The constitutional amendment process is ongoing. What would be your major recommendation in terms of the amendment of the Constitution? The priorities.
The priorities. Well, two major areas, as far as I'm concerned, the issue of a constitutional amendment in the area of security. I am no matter the the perceived or anticipated shortcomings, Nigeria would deserve to have a state police. State police should be on the front burner of any form of constitutional amendment. And if you're not going to have a state police, allow the state to set up their own security outfit with the power to carry arms. You can make it that it is only the federal government that we ensure that, be in charge of how they are going to be giving licenses to carry arms. But you cannot have a state security outfit that is not armed, and you want that one to confront crime, kidnapping, and the rest. Furthermore, in the economic sector, there should be the need to enable the state governments to play in several areas in the exclusive legislative list. For example, what is wrong in a state, maybe in the south or Lagos, for example? Why can't it have its own port? Yes, this is an area that is exclusively reserved for the federal government. If a state has the money to do a seaport where ships will be landing, the berth there, what is wrong? So, education. It is still the National Universities Commission is still the body charged with the responsibility of approving the establishments of state universities or even private universities,
and also accrediting their courses.
Yes.
Accrediting their courses. Thank you, Prof. And also accrediting their courses. I do not see anything wrong in having a constitutional amendment that will enable states. We should credit these state governments with the ability to do the needful. Look at it now. I read online today that there is one private secondary school, 𝐶𝐈𝐒 secondary school. They said about 27 of their students called more than 300. So if a private secondary school can do this, why shouldn't the state government be able to say?
Let us see. There's a lot to touch on, really, and we're just about 5-7 minutes to the end of the show. So, Barrister, I'd like you to ask your question as we wrap up. Final question, and then we'll get the final thought of Prof as well. Very quickly, Barrister. Yes.
A few people feel I have turned it into our own specialized discussion because most of my questions have been on the judiciary. So let me move a little bit away from the judiciary. A couple of days ago, we read in the papers a comment attributed to Ndume, who is a member of the National Assembly, while they were having a plenary discussion on death sentence for those who steal Nigeria's money. And he was reported to have said those who steal in billions, he would not advocate for death sentence for them, except they steal in trillions. I don't know how you received, that comment or statement. I know that, of course, whatever is said on the floor of the House, no action can follow, but the sensitivity of Nigerians is what I considered. Let me hear your position on that statement.
The issue of death sentence for looters is clearly a political decision. There are some countries, including China, if you do that, it is death sentence. I think the proper thing should not be whether you have stolen in billions or trillions. You see, whether you can steal billions or trillions is a question of what access you have to public treasury. Those who steal in billions do so because they have access to enormous public funds. Crime, murder is criminalized and does not have to do with whether the victim, whether the person murdered is a wealthy man or a poor man. Murder is murder. As far as I'm concerned, public corruption is public corruption. Once if you want to impose death penalty on it, the quantum of what you have stolen should have no relevance.
Okay, let's quickly get some comments and then get Prof's final thoughts and we wrap up. 𝐃𝐈𝐒 says, on what mandate are the legislators standing? Is it on constitutional mandate or personal mandate? It is similar to Rivers State where assembly members were standing on Wike's mandate but not on the constitution of the country. Thank you very much. It says, whatever the FCC is doing, it must be in accordance with the law that set up the commission. Whenever they see anything wrong with the mode of operation, they should approach the National Assembly to seek moderation or alteration. It's just unfortunate that some people in the country see themselves as above the law of the land. So, Prof, I'd like you to wrap up with our guest for the day because our time is almost up already, Prof.
Yeah, I think the last thing I would like to talk about is the increasing harassment of journalists. I mean, it seems that this government human rights record, by the time it closes before 2027, will be very dismal. Why is the government and some of the key officers like Benjamin and Miller getting involved in illegal arrest of journalists? I am referring to the recent situation with First News and other similar occurrences in recent times.
Yeah, very quickly, senior advocate, we need to wrap up very quickly.
Well, it is a very embarrassing development. We have always had press freedom in Nigeria. The law reports are repeated.
Oh. Hello. Okay.
Yeah. Hello, sir.
Yes. Yeah. I think we lost connection with you there. Yes.
Now.
Yeah, we can hear you now. We can hear you now. We can hear you now, sir. Yes.
What I said is the most embarrassing, unacceptable trend. And those who are harassing journalists know that they are doing so in a manner that is offensive to the law. Just like I've said, it is the players, the rules, the Constitution guarantees press freedom. But where some overzealous members of the executive or overzealous political office holders wantonly trample on the rights of journalists. First, I will suggest that the appropriate thing for those journalists or their associations is to protest. They can also approach the courts, because there is a tendency, you see, power corrupts. Absolute power corrupts absolutely. It's unfortunate. The chief of staff to the president is a lawyer. He knows very well that journalists are entitled to practice their profession in an atmosphere of freedom, no prior censure. You don't harass them. But when this happens,
right,
I expect those who are harassed to approach the court. You will remember in the Second Republic, there are several cases filed by journalists.
Yes, we need to wrap up. We need to wrap up, sir. I mean, it's been most intriguing having you on the podium this morning. I wish you could go on and on, but our time is already up. Thank you so much, Barrister. I'd like you to appreciate our guests.
Oh yes, Leonard Silk, it's been wonderful having you around, and I guess quite a sizable number of the people who have listened today have gained tremendously from your wealth of knowledge.
Yeah.
Thank you very much.
And Prof, please appreciate our guest for today.
Yeah, I thank him for his great knowledge and wisdom. I wish him the best in his career as a senior advocate of Nigeria.
Thank you so much, Olalekan SCN. Thank you so much, Leonard Silk. Let me sound like Barrister now for joining us. As I said, he has a very impressive resume. He's handled several cases. I don't even know where to start from. But let me just summarize by saying that he's handled a number of criminal and civil matters in Nigeria. Landmark cases, I must say. It's been most intriguing and informative having you on the podium. Thank you so much, sir, for joining us. Thank you to Prof and Barrister, our panelists. Thank you to our listeners as well for dropping your comment. Special thanks to my producer, 𝐷𝐿𝐴 for the support as well. Just a quick information before I go. Smart Kids and Parents Children's Day is around the corner. Don't forget the 32 FM Children's Day Hangout is happening at Palms Mall Ring Road, Ibadan, next Saturday, 25th of May from 11 a.m. Get your tickets at our office right here at 4th floor Cocoa House, Dugbe, Ibadan. 3,000 naira only. There's a lot that awaits you there at that event. You have rides at the Palms Mall. You can also get laughter packs with goodies, fun games, dance, opportunity to display your talent, and so much more next Saturday, 25th of May. To join us, my name is 𝐿OLORUNTOBA Yusuf. Enjoy the rest of your Saturday morning. Bye for now.